A very good afternoon to all of you. A very warm welcome to all of you. I'm Chye. I'm heading up the Southeast Asia Data and Privacy, and I'm one of the facilitators today, one of the speakers. I'm also running the Deloitte Cyber team for Deloitte Vietnam. I have been in the market for 34 years now. With me, we have Chris, the Associate Director, who has 13 over years in the market, most of the time in Deloitte, as well as Tung, has been 7 years, who is a manager in Deloitte under risk advisory. All three of us have been started looking at PDPD since the draft time, and in fact working with the Southeast Asia team that has more than 10 over years in the region. Singapore backed in enforced in 2013, but drafting stage we are already involving. As well as also the rest of the region, including Thailand, Indonesia, and Philippines. Right. We also have our SME in Singapore, Thailand, Indonesia, and Philippines that are not presented here. Having said that, they have been involving in managing the data privacy for the region and involved in the team offering the services to the region, including Vietnam. What it meant really is that we have the needed experience to help you to understand and lower the impact should there be any days that Ministry of Public Security coming after you in terms of asking you for a response due to a breach. In today's session, I just want to highlight that what we're going to go through is really diving into the PDP privacy service as well as the impact that you need. What you're seeing here is really the brochures. We are not having a lot of time to go through every single detail, so we actually captured most of the question that you might have from the brochure. Feel free to take a screenshot of this and then go to the through the QR code to access to the brochures. We believe that you can read up as well, and feel free to reach out to us should there be any question. Another slide, please. Okay, today ultimately what we want to show you is that we will show you the impact of the PDPD to your organization. That's probably the reason that you want to attend this session. After that, I will also put in some perspective of the timeline. Let me start off with this potential sanction. There are 3 possible types of sanction clustered under administrative, civil, and criminals. Ultimately, this particular administrative is coming from the non-compliance, where we actually understand that from the different degree that listed down there, up to 70 million for each violation. So this is something that you want to know that PDPD can bring that to you. On the right hand side is actually the criminal relevant regulations. So that is criminal sanction that by the different regulation over there as well, that itself could involve in potential jail time. Silver sanction will be subjected to for example, even your consumer coming after you due to some so-called leakage of his or personal data that caused the privacy being breached. So these are all the existing bring forward by the different regulation, but PDPD will entitle or will bring you towards. So for the current approach, I just want to take this opportunity, right, to share that we are not a lawyer that typically focus on explaining the different regulation. Today is not a law class as well. What we do is further step to map the laws into the approach or framework to guide you or the organization on how to operationalize in your organization and put your organization business into context so that you can actually comply in the day-to-day of processing of your personal data. By knowing the law does not give organization or you yourself the ability to comply. Example, knowing that the PDPD requires you to get consent, but how exactly you going to get you probably will need to know how to, for example, in the web form that you're collecting data, you will need to put a consent in there, and how that is being integrated, and how the operation or processes managing that consent coming in. That is something that is really coming beyond the law itself. Later on, I think Chris and Tung will dive into more details. For now, we can move on to the next slide. This is a PDP implementation timeline. As you know, 1st of July, which has already passed, it actually PDPD gets into effect on that day. We are already 3 weeks into the July, and the next milestone is actually 30th of August, where you are expected to submit the dossier, where basically as a result of the data protection impact assessment, ultimately it's talking about what this personal data processing could have an impact with reference to your processing activities. And this is, you are expected to put all this into a dossier to submit to MPS. But at this point in time, just to take note that MPS portal is still not live yet. So you still have some time, but that's something that you are expected to do. And finally, this is tentative as far as the draft is concerned. We are aware that 1st of December, it will have the administrative sanction degree that been come into force. And that will define the actual penalty or actual sanction that you will be subject to, should there be any breach. I just want to touch on the fact that Deloitte has the solution that has been proven in the different countries, and that itself will then address the impact of the different sanction that you are potentially subject to. For example, compliance, administrative consent, administrative sanction. And what we are putting together is really the experienced consultant in the region, making up not only a local team, plus also leveraging on those consultants that has walked the journey, like Singapore, where it actually implemented since 2013, and what kind of breach situation, how to handle regulator questioning by responding correctly and orchestrating correctly. So we do have a solution that we going to just to give you an overview with the flexibility of the budget. Ultimately, it can be as low as 10,000 US a year, where you then can access to a so-called experienced consultant to address to your so-called breach concern, or how to address, how to operationalize certain aspect of the PDPD. With that, I'm going to pass on to Tung to dive into more detail of the sanction to give you a better view of the detail. Over to you.
Thank you, Charlie. Hi, everyone. So I'm Tung from Deloitte Vietnam. I'm glad to have you all here with us. So I will try to explain this in like the most brief and concise way as possible. And in the meantime, some of the slides I will translate to Vietnamese, because I understand that some of the participants may require like some more detailed explanation in Vietnamese. So if you are worried about us going through too fast or speaking all in English, so some crucial regulation I will translate to Vietnamese for you. So regarding this draft cybersecurity administrative sanction decree, this is still in a draft phase, and according to the Ministry of Public Security, they tentatively expect to release it and have it goes into effective on the 1st of December 2023. The most important, like as you can see here, the amount of monetary sanction is going to increase upon the severity and also the repeated violation that the Ministry of Public Security after their inspection, they noted that the organization have violated. And I just want to highlight that in this decree, they also mentioned several injunctions on top of monetary sanction. For example, they can take away your business, they can suspend your business license for 3 months to even 1 year. The actual detail is subjected to change because this is still a draft decree that is open for public comments, and the most damning amount of monetary damage here is the 3 to 5% total revenue in Vietnam for the previous year. That the violation have been confirmed to have been took place by the Ministry of Public Security. So I will try to briefly summarize this detail in Vietnamese for the other participant. Dạ rồi, chào mọi người ạ. Thì hiện nay là bên phía Deloitte bọn em có nghiên cứu sơ bộ về những cái nghị định, trong đó có cái nghị định về xử phạt hành chính do Bộ Công an đề xuất đưa ra và dự kiến sẽ đi vào hiệu lực trong ngày 1 tháng 12 năm 2023. Thì như là khi nãy bác Charlie có trao đổi thì cho tới cái thời điểm này là chưa có một cái nghị định nào ban hành về cái việc xử phạt. Tuy nhiên theo như tư vấn của những đơn vị luật mà họ có tìm hiểu và có biết qua về cái bộ luật này, thì họ có nói là sẽ căn cứ vào những cái bộ luật khác. Cái bộ luật cũng có một chút tương đồng với cái việc mà bảo vệ dữ liệu để mà xử phạt. Thì cái slide trước là cái slide về timeline là cho tới cái ngày mà cái dự thảo nghị định xử phạt hành chính này nó đi vào hiệu lực thì sẽ một doanh nghiệp có thể sẽ bị xử phạt lên tới 70 triệu về mà hành chính cho mỗi lần vi phạm. Còn khi mà cái nghị định xử phạt hành chính này nó được ban hành thì cái số tiền mà sẽ bị xử phạt nó sẽ tăng lên rất là nhiều. Đồng thời ở đây thì mình cũng thấy là có một cái trường hợp cao nhất là một doanh nghiệp có thể bị xử phạt là từ 3 tới 5% tổng doanh thu tại Việt Nam trong cái năm liền kề, cái năm liền trước của cái lần vi phạm mà được phát hiện. Trong cái buổi hôm nay thì em cũng sẽ dành ra một vài thời gian để mà phiên dịch những cái slide mà nó mấu chốt liên quan tới luật cũng như là liên quan tới cái nghị định này cho các thành viên mà có thể là nghe tiếng Anh chưa có được rõ lắm thì em cũng sẽ có thể dịch để mà giải đáp được cho mình. Okay. Let's move on to the next slide. Is the requirement for organizations. What is required for your organization for this particular decree? So we have summarized here the main point that each organization need to prepare for and need to be like at least know what they need to do. So I will highlight some of the main topic that is pretty relevant for most organizations. So the requirement will be split into two parts. If our organization have any access, like collect access, like view, delete, modify personal data, then they will need to follow all the information, all the step requirement here in the process section. Additionally, if your organization store the data in a cloud that have a cloud database outside of Vietnam territory, outside of Vietnam, then there will be additional requirement that an organization need to comply with. So just a brief like example on the scenario. If you are a subsidiary of a multinational corporation and you have to submit you have to transfer data back to the headquarters in another country outside Vietnam, then if that subset of data have personal information, then you will have to comply with this requirement. And like what I have mentioned before, if you somehow store the data on the cloud and your cloud service doesn't have an availability zone or a database within Vietnam territory, or then it's most likely that you will have to comply with the requirement in the PDPD. So in this slide, I think most people will have a question regarding, okay, so what is a data protection officer? This is not explicitly mentioned in the PDPD in the Decree 13, but it mentioned that the organization need to appoint someone responsible for data protection within the organization, and typically that position is the data protection officer. And then your next question will be, okay, so who should be the PDPD? Typically, the PD, who should be the DPO, the data protection officer within your company. So he or she should be knowledgeable in both multiple facets, the legal facet, the IT, and the risk compliance, because most of the compliance come from the PDPD, and then in order to enforce, in order to implement the technical measure, you need to have understanding about your organization, like technical measure and what procedure process that can be used to secure the personal data that is stored and processed within your organization. So I have seen organization, they appoint not just people from legal, but a wide variety of background. It's vital for the data protection officer to have a deep understanding of your organization business processes, because some department, some business department, they can declare that, okay, we are not collecting any personal data, but it turns out that they do. And it is the data protection officer job to really walk through and recognize those instances and really identify that to prevent violation of data of personal data processing. And the next, I think the next requirement that a lot of people is going to ask about is the data protection impact assessment, because like up until the PDPD comes out, not many people in Vietnam know what it is. So and what should they do? And unfortunately, within the PDPD itself, they currently no detailed guidelines to properly conduct the impact assessment. So what we can do, what you can do as an organization, and what we can help you is to provide our professional regional expertise and our experience working for the compliance for other countries with similar regulation. For example, we have the GDPR in EU, and we have PDPA, the Personal Data Protection Act in Singapore, and in Malaysia also have one, and Philippines also have one, and then we have the same legal, same law within the Indonesia as well. So for the DPIA, if you read up the PDPD, the Ministry of Public Security have a form, have a template for organization to refer to. However, that template is very basic. They don't have much information in it. Like they just the template basically just say, okay, please refer to these attachments that we have to evaluate on whether we did the risk assessment correctly, impact assessment correctly, which is really doesn't help much. That is why organization really need to look to the similar regulation compliance procedures, and seek out consultants to help them with the preparing the DPIA for the Ministry of Public Security. We also received some questions regarding, okay, so how exactly are we implementing organizational and technical measures to protect personal data? This in the PDPD still, unfortunately, they don't have an exact requirement. They don't have an exact guideline. They just inform businesses and organizations that, okay, you should have it. If you don't have it, then you can potentially be sanctioned. In the draft sanction, administrative sanction decree also mentioned that, okay, there will be some monetary sanction for not implementing organizational or technical measure, but they haven't give any guideline. So what consultants like Deloitte can do is to still implement best practice across the region, across global. For example, the NIST is one of the framework that is great for organization to establish some basic framework for organizational and technical measure to protect not just personal data, but data protection as a whole. And regarding the cross-border transfer, so the cross-border transfer here is one of the more nuanced requirement that it will be up to each organization to really look into their own processes and understand how the data is flow between them and even their storage location. Like for most organizations, they don't even know where their data is located, especially when they use a cloud service. So this is also one of the main concern that usually we will have to conduct an internal review of and draw up data flow diagram to understand where your data is going. So what can Deloitte help in with these requirements? We have been deliver the same data privacy compliance services for clients in multiple industry. Not like you can see from our credential that this is not just one. Like we are not just focusing on one or two industry, because data personal data protection apply to everyone, not just some company in e-commerce or banking. That is applied to everyone, every organization, every company in the market. That is why if you are collecting, processing, or have any tangential access to personal data, then like the organization in your company will need to be like stay on high alert and really understand what is required and what you should do. So in terms of what we can offer, it's not just going to be legal compliance, because understanding the law, as Charlie mentioned before, understanding the law is not, and knowing how to comply with the law does not mean that you can like effectively like reach that compliance immediately. But you will have to make changes, transform your internal processes. For example, if you have requirement, okay, you have to ask consent before you collect the data, then you will have to ask consent every time. How do you integrate that into your own internal process to make sure that it happens every time? And it's not just going to be a one-off compliance activity. That will be just, okay, let's do this for 1 or 2 days or 1 or 2 weeks. And then after that, just follow your own process. And when the Ministry of Public security comms, they discover, okay, you only do for some date, and then you just forget everything about consent, you forget everything about compliance, and that would expose your organization to the risk of being administratively sanctioned by the MPS. Okay, so I will also quickly go through the overview of the law, because the first few couple of minutes we focusing on answering some of the more asked questions by the participants. So regarding the law and regulation, we want to highlight that PDPD, even though it is the most comprehensive set of regulation that directly address personal data protection, it's not the first one, or it's not, neither is it the only one. There have been more than 60 regulation that mention or have some requirement of personal data protection, but this law does not directly require or address or put any administrative sanction on the organization to compel them to comply. That is why PDPD now have that much importance compared to the other set of laws. So in the PDPD, they outlines 8 principles of data protection. We have the lawfulness, transparency, accuracy, purpose limitation, data minimization, integrity and confidentiality, storage limitation, and accountability. I will focus on these 2 sets of information, which is transparency and purpose limitation. I will also translate into Vietnamese because this set of principle is fairly new for Vietnam market. So for transparency, basically you have to inform the data subject, the individual that you are collecting the data from. You have to inform them, okay, what are you doing with their personal data? And if you are for the purpose limitation, you have to let them know, okay, so once we collect your data, we are going to use them for this specific purpose. You have to make it explicitly clear for your data subject. If you don't do, if there is a lack of that kind of processes, basically you are open yourself up to sanction. Yeah. Thì ở đây là em cũng muốn nói rõ lên 2 cái yếu tố ở bên phía cái nghị định 13, nghị định về bảo vệ dữ liệu cá nhân, thì có 2 cái yếu tố khá là quan trọng mà nó mới xuất hiện ở cái thị trường Việt Nam, đó là cái yếu tố về mặt là gọi là minh bạch trong cái quá trình thu thập và xử lý dữ liệu. Thì khi mà một doanh nghiệp mà thu thập bất kỳ dữ liệu nào gọi là dữ liệu cá nhân đó, thì sẽ còn phải cho cái người cung cấp dữ liệu biết, hoặc chủ thể dữ liệu biết là dữ liệu cá nhân đó đang được sử dụng như thế nào, vì mục đích gì, và cũng cho phép họ được truy vấn cái dữ liệu mà doanh nghiệp mình đang sở hữu, đang thu thập, đang sở hữu, đang xử lý mà từ họ đó. Đồng thời cái một purpose limitation, tức là khi mà mình thu thập dữ liệu thì vì mục đích nào là phải nói rõ cho cái chủ thể dữ liệu trước khi mà thu thập dữ liệu của họ đó. Chứ nếu mà mình không có thể tuân thủ được 2 cái yếu tố này thì đó là 2 cái yếu tố mà được lặp đi lặp lại trong cái dự thảo về xử phạt hành chính về cái việc bảo vệ dữ liệu cá nhân. Cho nên là hai cái yếu tố này nó sẽ rất là quan trọng. Em sẽ đi sâu vào trong cái mục liên quan tới cái gọi là quyền của chủ thể dữ liệu trong các slide tiếp theo. Okay, so what is personal data? We actually have the Vietnamese like verbatim copy from the PDPD and the translation of the Vietnamese copy. So basically any electronic information, not hard copy, electronic information that is associated with a person or help identify a person. And within the PDPD, they classify some information as basic personal information and sensitive personal information. So sensitive personal information will require further, like a lot more technical measure to ensure that it doesn't leak, it doesn't go anywhere that it's not supposed to. So to ensure that those data is properly secure within the processing organization. So for this information, you can read further in the PDPD. This is just a verbatim copy of the definition of personal data. So we move on to this one, which is a more important, which is the consent, and basically just the data subject rights that is defined within the PDPD. So when you collect the data from the data subject, the consent must be in writing. It must be explicit, voluntary, and affirmative, which means it cannot be like a question like, okay, so can I collect this from you, and you don't, the data subject haven't give any indication, and you claim that okay, they verbally say they consent, or they did some gesture, they did some gesture that make you think that they gave consent. Is not acceptable for PDPD. It must be in writing, explicit, voluntary, and affirmative. And each and every purpose that you are using their data for, you need to list it out, let them read it, let them agree to them. They can agree to the purpose completely in its entirety or partially. Like the data subject, they can give partial consent. So if you collect the data for some specific purpose, you have to list them out, and if they don't agree with some of them, they need to be able to only agree to some, not all. And if they no longer want to give you consent, you need to give them a mechanism to withdraw their consent, and you will stop processing their personal data. And also, there is a specific article in the PDPD that are related to children, processing personal data of children. So if there is a potential possibility that you are collecting data from children, and so you will have to verify the age of the child. If the child is 7 years old and below, then their guardian or their family need to give their consent. The child cannot give their consent. If the child is between 7 and reaching adulthood, then you will need both of the consent of the child and the guardian and family. And the organization will need to provide the data subject with access to their own personal data within your organization, which I have mentioned previously. Basically, there must be a mechanism for them to view, to update, to obtain a copy, to delete, to make changes to the personal data that you are storing in your organization. And this will apply to all data, like personal data processing activities. And I think that pretty much there is a small section related to data controller and data processor. However, that is really up to most organizations that have direct access to personal data will be data processor. There are rarely exceptions. If you can look at the personal data, you are the data processor. whether you are the data controller or not, it depends on, are you the one deciding what to do with the personal data? If you are, then you are also the controller. And they, in an organization, that organization can be the processor, and they can also employ all the third party to help them with some of the processes. Those third party is also the processor that you need to declare with the Ministry of Public Security. So in the interest of time, I will pass the next session related to our privacy service to Mr. Chris. We will have a quick Q&A session at the end of the webinar to answer your question. So please give us your question in the Q&A box. Okay.
Okay, thank you, Tung. So after this overview on the latest sanction decree, possible sanctions in terms of in case of repeated violations against the PDPD requirements, and after this overview given by Tung on the principles of the Decree 13 on what you need to do, I think you have an overview now of there are a lot of things on your plate, and unfortunately, because this decree was issued mid of April, enforced on 1st of July, without transition period, there are a lot of things that the organization needs to implement, and there are also strict timelines from the Ministry of Public Security. So we would like to provide you an overview of some of the relevant services that Deloitte can provide to your organization. Actually, data privacy and data protection is a very broad topic with a lot of which involves a lot of different type of services. However, we would like to emphasize today only on two, which we deem are the most relevant for the organizations today in Vietnam in regards to the PDPD, which is enforced for 3 weeks already. The number one is to help you to implement the data privacy framework. What we call data privacy framework is the set of documents, all the policies, procedures, documents, guidelines, and training, which are required in order to manage the privacy within your organization. So typically when we do that for our clients, when we help them to implement the data privacy framework, we do the gap assessment, meaning we look at their current practice, their current privacy corporate documents, and we do the gap assessment with the Decree 13 requirements. And we give the action plan so our clients understand what must be done in regards to the compliance with Decree 13. And also we can give recommendations on the best practice, not only in regards to Vietnam Decree 13, but also on the what's the practice that we observe, such as in Europe or Singapore, right? So that's the gap assessment. Then there is one very important aspect. Sorry, I will just try to use the pointer. It's the dossier preparation on the right. Okay, the dossier preparation. So Tung mentioned before, whenever your organization process personal data, you need to do the impact assessment. We call that DPIA, which stands for Data Protection Impact Assessment. So this impact assessment needs to be done in order to prepare the dossier and submit the dossier 60 days after the time you process personal data. Because the Decree 13 was enforced on 1st of July, it means that there is a deadline from the Ministry of Public Security to submit the dossier by the 30th of August. Okay. Besides the personal data processing, if you do any cross-border transfer, Tung mentioned before, if you are sending personal data of Vietnamese citizens to your regional or global headquarters outside of Vietnam, that's cross-border transfer. If you are using any systems on the cloud for which the data center is outside of Vietnam, and those systems store personal data of Vietnamese citizens, that's also cross-border transfer. So you need to do also what we call a CTIA, which is cross-border transfer impact assessment, and you also need to submit that dossier by the 30th of August. Besides the dossier preparation, we also help to develop all the rest of the documents that you need, like the external privacy notice that your customers can refer to, the internal privacy notice, the guidelines for your employees, the non-disclosure clause in the contract, for instance, for your employees, the training decks. So all those set of documents we can provide you as part of this service. Okay, so that's number one. That's the service that we actually start to provide to some clients in Vietnam. And then number two, which is also, we deem that it's quite relevant in the context of Vietnam, is data protection officer as a service. Data protection, like DPO as a service on the right side, the blue box that you see on the right. So Tung mentioned before, one of the requirements of Decree 13 is to have someone in charge of personal data protection. Usually we refer to that person as DPO. Okay, DPO could stand for Data Protection Officer or Data Privacy Officer. This position is new in Vietnam, so it's very hard to find someone who has exposure to manage data privacy, unless you find someone who has been working in Europe under EU GDPR, or who has been working as DPO in Singapore under Singapore PDPA. And the DPO also involves knowledge, as Tung mentioned before, right? The DPO must understand the legal requirements, have the compliance and risk management mindset, and understand IT, because at the end of the day, all those personal data are managed in the systems, right? So these cover multiple facets of the organization. So the person that you appoint in order to conduct all those operations will certainly need to have some support. So the service number two that we put here, Data Protection Officer as a service, is, you can see that as an outline. Whenever your DPO function needs any support, any guidance, any advisory, any training, for example, you need to have some template for DPIA. You don't know how to do DPIA. Well, DPO as a service can provide you the template, can help you to review the dossier before you submit to MPS. After you submit the dossier to MPS, the MPS will have questions. Maybe to we ask you to revise the dossier. We can also help you to respond to the query from the regulator. Or if there is any complaints for your, let's say, your customers or even employees regarding the personal data processing, then we can also help you to prepare the response. So the DPO as a service, we call that is a retainer service, meaning that we have people at Deloitte and standby, ready to respond to any of your queries. So we have SLAs, meaning that if you reach out to Deloitte on Monday for a basic query, we have 2 days, like Wednesday, we need to respond to you. If it's a more complex query, we will have like 5 days to respond to you. So it's basically, number two is a hotline, a package of man-days. It's flexible in the sense that you can buy, like, it could be 5 man-days, it could be 10, 15, depends on your need, right? So we see that number two is also quite suitable for the organization in Vietnam in the context of the newly Decree 13, which is implemented, enforced just recently. I will hand over just to Tung to explain those two services in Vietnamese.
Thì em nói sơ qua về hai cái dịch vụ chính mà Deloitte sẽ hỗ trợ. Thứ nhất là về cái tư vấn tuân thủ, tư vấn phát triển cái data privacy framework, tức là cái chính sách cũng như các cái khung quản trị để mà đảm bảo cái việc mà cái quyền cái data privacy của doanh nghiệp được thực hiện đúng theo cái chuẩn của Nghị định số 13. Thì đối với cái phần này nó sẽ chia ra làm ba cấu phần tùy theo cái nhu cầu của doanh nghiệp. Có những tổ chức doanh nghiệp là chưa có một cái chính sách nào liên quan tới quyền riêng tư, dữ liệu cá nhân, thì lúc đó sẽ cần Deloitte tới để mà hỗ trợ phát triển cái chính sách, cũng như là hoặc là nếu mà đã có rồi nhưng mà chưa có được đầy đủ, hoặc là chưa có cảm thấy tự tin là sẽ phải cần phải có Deloitte review, kiểu như xem qua rồi đánh giá xem có còn thiếu cái mục nào hay không, thì đó sẽ là cái bước đầu tiên. Là mình phải có chính sách trước, ban hành chính sách, ban hành những cái quy định, những cái thủ tục trước, xong rồi sau đó là sẽ là thực hiện một cái gap assessment. Ở đây là đánh giá về cái quy trình, đánh giá xem cái quy trình hiện tại so với cái mà yêu cầu của bên nghị định số 13 là nó đã đủ để mà phục vụ, đủ để mà thông báo cũng như là thu thập các cái quyền, cái consent, cái quyền mà chủ thể sở hữu dữ liệu đã cung cấp hay chưa. Đó thì trong trường hợp mà doanh nghiệp chưa có định hình một cái quy trình, hoặc là cái quy trình chưa hề có nhắc tới cái quyền của chủ sở hữu dữ liệu, hoặc là quan tâm tới cái việc mà phải phân biệt dữ liệu nào là dữ liệu cơ bản, dữ liệu nào là dữ liệu cá nhân, dữ liệu nào không phải dữ liệu cá nhân, đó thì sẽ còn phải thực hiện đánh giá là cái gap assessment, là đánh giá cái quy trình để mà biết được còn phải cải thiện những mức nào. Rồi cái dịch vụ cũng trong cùng cái dịch vụ này thì cái phần cuối cùng đó là chuẩn bị cái bản báo cáo để mà gửi cho Bộ Công an. Thì cái bản báo cáo này theo như cái yêu cầu trong cái nghị định số 13 đó, thì nó sẽ cần phải được gửi giống như cái DPA, tức là cái báo cáo đánh giá impact, đánh giá độ ảnh hưởng của cái việc xử lý dữ liệu đó, là sẽ cần phải gửi trong vòng 60 ngày kể từ cái ngày xử lý dữ liệu cho Bộ Công an. Đó là lý do mà khi nãy trong cái timeline mà bác Charlie có đề cập, đó là có cái ngày 30 tháng 8. Tại vì cái nghị định này nó được đi vào hoạt động và nó có hiệu lực từ ngày 1 tháng 7, cho nên sau 30 ngày thì tới cái ngày 30 tháng 8 xem như là cái hạn cuối của rất là nhiều cái hoạt động xử lý dữ liệu cá nhân mà cái bộ luật nó bắt đầu đi vào hiệu lực. Thì có những cái như là cái báo cáo về đánh giá độ ảnh hưởng của cái việc xử lý dữ liệu, đồng thời có cái báo cáo là đánh giá độ ảnh hưởng của cái việc truyền dữ liệu ra nước ngoài. Đó, thì khi nãy em có đề cập đến cái việc xử lý dữ liệu, thì mình sẽ có một cái danh sách cái yêu cầu riêng. Rồi cái việc mà khi mà dữ liệu ra nước ngoài cũng có một cái danh sách yêu cầu riêng. Đó thì những cái này là phía Deloitte cũng có những cái template, những cái biểu mẫu chuẩn theo như những cái dự án trước mà Deloitte đã làm cho GDPR, PDPA của các cái nước ở trong khu vực đó, để mà hỗ trợ cho doanh nghiệp có thể tuân thủ cái nghị định số 13 nhanh chóng và dễ dàng. Cái phần dịch vụ thứ hai đó là cái dịch vụ Data Protection Officer as a Service, tức là Deloitte sẽ làm một cái như là một cái đơn vị đứng hỗ trợ về mặt hotline để mà tư vấn cũng như là thực hiện đào tạo và hỗ trợ cho bộ phận quản lý dữ liệu, bảo vệ dữ liệu ở nội bộ của doanh nghiệp của mình. Đó thì cái dịch vụ này nó sẽ tương đối là phù hợp với túi tiền của nhiều doanh nghiệp hơn, trong trường hợp là ok, doanh nghiệp sẵn sàng thực hiện, giống như là chuẩn bị hết rồi, chỉ cần một vài cái review, hoặc là chỉ cần Deloitte làm hotline để mà tư vấn khi mà có chuyện cần thôi. Thì đây cũng là một cái dịch vụ để mà bên mình cân nhắc, là những cái hỗ trợ về mặt nhỏ lẻ nhất thời, khi mà mình đang chuẩn bị giống như tự nâng cao những cái kiến thức về bảo vệ cái quyền riêng tư, quyền dữ liệu của các chủ thể dữ liệu. Ok.
Okay, thank you, Tung. So if you can move please to the next slide. So just a reminder of the timeline that we have shown already previously. It's enforced since 1st of July, so it's already into effect, the Decree 13. There is this deadline, which is very high priority whenever we work for all our clients. It could be data privacy advisory framework or the DPO as a service. Our highest priority that we advise is to work on the DPIA, the data protection impact assessment, because there is the deadline to submit the dossier to MPS by 30th of August. And again, I think we have mentioned that before, but if you look at the Decree 13, you can look at the appendix. I think if I remember correctly, is the form 04 to submit the DPIA, or the form 06 for cross-border transfer. On top of my mind, those are the number of the appendix. Excuse me if I'm not correct on the number, but the forms are very, very, very simple. But there is no guidelines whatsoever on how to actually conduct the impact assessments. Though that's where you might have to use an experienced advisor to provide you templates that we, for instance, Deloitte, we already have those templates to conduct DPIA and cross-border transfer, already mapped with the requirement of Decree 13, help you to understand how to conduct, like we usually do for clients workshops, to explain to the process owner from HR, from commercial, from IT, how to conduct the DPIA. And then before you submit the dossier to MPS, we also help you to review those dossiers, comment. So we help you to ensure that you do the right thing. So it's important to have in mind that there is this deadline at the end of August to submit those dossiers. Next, please, Tung. So we are coming to the end of our presentation. We just put it here, a list of questions that you can please screenshot this page. Like you have the QR code to access to our webpage on data privacy. You can download our brochure to understand more about our services. You can contact us. You have the contact here, my email address and Tung email address as well. We have put here just few questions that you can consider if you decide to reach out to Deloitte to understand how we can help you. So those questions are basically the basic questions that we need to know in order to propose you the suitable services for your organizations. So we have just few minutes left. We have seen, so there are a couple of questions I see that have been raised on the Q&A chat box. We will follow up by email to you for the questions that we don't have time to answer. Some questions we already answered directly. Okay, I will just pick some questions. Like for instance, the first question has been raised for the HR in the recruitment process. If the collection of personal information for candidates and employees, does it fall under the Decree 13? So the response is yes, because HR is a typical department that is involved in personal data processing, right? It's because they have to process like personal information of candidates or employees. So typically, yes, that's fall under the scope of Decree 13. To put it simple, like whenever you have processed any information that could help to identify an individual, right? It could be the name, could be the address, could be the telephone number, could be a bank account. That's more like sensitive information. All those information, right, it will fall under the Decree 13. If you have the information that does not allow you to identify an individual, then that's not in the scope of Decree 13. Put it simple that way. If you have any information that allow you to identify a person, a conservative approach would be to consider that it's in the scope of the Decree 13. Then there is a question about the consent of the children. So as per our reading of Decree 13, the children above 7 years old can give their consent, but it must be goes along with the consent from their guardian or the parents, right? So you must have both. But below 7 years old, our understanding of the Decree 13 is that you cannot get a consent of the children. You must get the consent through the guardian or parent. There is a question about if we do offline business. No, sorry, not this one. Yeah, a question about the personal data that is stored on hard copy only, which means that it's not on any system, not on any cloud, not on any database. So our understanding of the Decree 13 is that it applies for the personal data which is managed on the in the how do you call that, in the kind of digital copy, right? So whenever it's in any system that falls under the scope of Decree 13. So but you have to make sure that there is absolutely no personal data stored on any system. I try to pick up the questions. During a networking event, I received name cards and I have informed that I will be contacting them for a follow-up coffee session. Does it fall under Decree 13? Yes, especially if you maintain a database with an Excel file stored in the cloud. Definitely that's under the scope of Decree 13 because you are collecting personal information, right? In the name cards, you will have the full name, so you can identify the person. You have the telephone number, you have the email address. So you collect the personal data in the Excel spreadsheet. So that's a digital copy. Plus, this digital copy is stored on the cloud. So if the cloud, you need to understand, right, what systems, that's why the gap assessment is important. You need to understand like the cloud that you are using, where is the data center, right? So that's why when we do the gap assessment, we always involve the IT department or the digital department, because those are the ones who know where are the data centers. So if the cloud that you are talking about has a data center outside of Vietnam, then yes, that's cross-border transfer. So the most common, the biggest cloud service provider like Amazon, Google, Microsoft, as of today, as far as I know, there is no data center in Vietnam. So there is cross-border transfer.
Just want to highlight that, Chris, just want to add on, right? Business contact in GDPR is considered a personal data that under the regulation. Likewise, PDPD, as opposed to Singapore PDPA doesn't. So that's one of the key differences that you need to note. But for PDPD in this context, yes, it is considered personal data. There are also some of the questions I'm not sure whether we have chance to answer, but I'm just looking at one. Talking about insurance company in the event of dispute between parties such as insurance contract dispute, right? This is subject can withdraw consent. In fact, this is one of the also one of the key differences between PDPD and the regulation in the region, be it Singapore, Thailand, or Indonesia. The data subject rights is much longer. Singapore is only 3 that you are more aligned to EU GDPR. And that itself, yes, you will need to be able to, you will need to be compliant. But having said that, if let's say there is certain law, just now the one of the obligation is lawfulness. So if let's say there's a law that you need to comply to, you need to follow, that give you the rights not to delay, because in order for you to not breach that particular regulation, then you can use that reason not to withdraw the consent. But otherwise, if you don't have a justification, you have to so-called withdraw to delete that. Yes. So technically, it's challenging. So there are for example, EU is more experienced in this, where one of my Finland customer actually have that tools that can trace back to the location of data, regardless of backup also. They then can actually remove it. So that is something that not common as far as this region is concerned. So I'm not sure whether we still have time on others. For those questions that not answered, we will definitely follow through, and feel free to, I think there is this, Chris, if you don't mind, we can, or Tung, if you don't mind, go back to that context slide, right, for the participant to take note of the your contact, and if in the case of reaching out to have similar query and so forth, and how that we can actually offer. Typically, one quick answer to the question is not an issue. Having said that, of course, we'll prioritize it. The point here is really that in order to fully comply, just now mentioned about certain services on framework to so-called standardize the protocol and the language across your organization. If you are a two-man team, then probably not an issue, because you can communicate among yourself and make sure that both of them comply to the protocol or the policy that you have. But if you are an organization that in hundreds and so forth, then making sure everyone is understood and performed according to policy so that you won't comply is a bit challenging. So that's where we are trying to come from the angle to provide certain so-called, because certain services that is go for more advisory in nature, pay as you use kind of concept. I leave it from here back to maybe Tung. You want to is there anything that you want to add, or Chris, you want to add? Otherwise, we can close off the webinar.
Yeah, we will. Thanks, Charlie. Thanks everyone for attending this today's webinar. So the questions, we will definitely follow up with each of the questions raised that we could not answer during this webinar. So thanks again everyone for attending, and we're looking forward to talking to you soon. Thank you.